A state high court sitting in Makurdi, Benue State, presided over by Justice Augustine Ityonyiman on Thursday, discharged and acquitted Andrew Ogbuja, a lecturer at the Benue State Polytechnic Ugbokolo, of the charges of rape and causing the death of a 13-year-old schoolgirl, Elizabeth Ochanya Ogbanje, in 2018. The Federal High Court in Makurdi, in a separate case, convicted the lecturer's wife, Felicia Ochanya Ogbanja, for negligence in the rape of the deceased teenager. Mr. Andrew and his son Victor, who are both maternal relations of the deceased, were accused of raping her until she fell ill and died. It can be recalled that the late Ochanya died after battling vesico-vaginal fistula and other health challenges for months. Her condition was said to be due to years of sexual molestation by her uncle, Andrew Ogbuja, and his son, Victor Ogbuja. She was admitted to a hospital but died on October 17, 2018.
Started 2013. When I was 5 years old, I went to my mother's sister's house to school because there was no school in my village. So when I went there, when I was 8, the son started sleeping with me. Then when the sister caught him, the sister then reported him to the father. Then the father scolded at him, and that was when the father started. So September, when I went to school, I was not feeling fine, so I came back home. I went to Federal Medical Center in Makurdi here. I spent 2 months and 5 days there, so they discharged us. When I now came home, then that was when I told my mother that when I was in my uncle's house, my uncle and his son, they were sleeping with me.
Justice Ityonyiman, while delivering judgment, held that the prosecution failed to prove its 4 counts against Andrew. He also held that the police investigators failed to subject the defendant to medical examination in order to match his specimen with the findings in the medical reports presented before the court. The judge added that 2 autopsy reports from the Federal Medical Center in Makurdi and the Nigeria Police Forensic Laboratory in Lagos left him in a difficult situation. He said the autopsy report from the medical center in Makurdi said Ogbanje died of natural cause. The one from the Police Forensic Laboratory said the deceased suffered diseases that were related to sexual abuse. He said, "I cannot pick and choose which of the autopsy reports to rely on in reaching a just conclusion of this case." Despite Ochanya narrating her ordeals at the hands of the Ogbuja in a video tendered before the court, Ityonyiman said, "It is regrettable that the deceased could not tell her story before she died." The judge, however, discharged the defendant. He said, "I hereby acquit and discharge the defendant of all the 4 counts charged." Meanwhile, Justice Mobolaji Olajuwon of the Federal High Court, Makurdi, while delivering judgment against the lecturer's wife, Felicia, held that the defendant failed in her duty to protect Ochanya from being sexually abused by her husband and son Victor. The judge held that Ochanya was being abused by the son of the defendant, but the defendant, who owed the deceased girl the duty of care to ensure that she was protected from such an act, failed in doing so, even when Mrs. Ogbuja's daughter Winifred drew her attention to the sexual assault. Justice Olajuwon further held that Felicia failed to challenge the prosecution's evidence that she threatened to send Ochanya out of her house if she told anyone about the sexual abuse. The judge said when Ochanya was examined, it was discovered that the membrane covering the vagina opening was not there, which is an indication that Ochanya had been deflowered. During examination, it was discovered that Ochanya had urinated on her bed as she could not hold her bladder. The medical report further stated that a working diagnosis of the fecal and urinary continence in a sexually abused child was made. Detailing Ms. Ogbanje's ordeal in the hands of the Ogbujas, the judge held that aside the physical injuries inflicted on the deceased, the sexual abuse itself would have scarred her for life, and I so hold. I hold that the defendant is guilty as charged in respect of count 1, and that the defendant is guilty as charged contrary to section 314 of the Criminal Code, and she is hereby convicted.